Hello students, today I am going to discuss with you the introduction of Civil Procedure Code 1908. Before we start, law can be divided into two groups. First group is called substantive laws and another group is called adjective or procedural laws. In substantive laws, we determine the rights and liabilities of the parties, whereas in the adjective or procedural laws, it prescribes the practice, procedure, and machinery of those rights and liabilities. The efficiency of any substantive law, to a great extent, depend upon the quality of procedural laws. Unless our procedures are simple, expeditious, and inexpensive, substantive laws, however good, are bound to fail in achieving their objects and reaching the goal. It is only the procedural law which put life into the substantive laws by providing a remedy and implement the well-known maxim ubi jus ibi remedium. It is very important for us to know the meaning of ubi jus ibi remedium. Ubi jus ibi remedium means where there is a right, there is a remedy. I repeat, where there is a right, there is a remedy. Our substantive law provides us the rights, whereas our procedural law provides us the remedy. The Indian Contract Act 1872, Transfer of Property Act, Indian Penal Code, etc. are some examples of substantive laws. While the Indian Evidence Act, Limitation Act, the Code of Civil Procedure, the Code of Criminal Procedure are some examples of procedural laws. Now our topic is Code of Civil Procedure 1908. The Code of Civil Procedure 1908 is an adjective law. It neither creates nor takes away any right. It is very important. It is neither intending to create any legal right nor it takes away any legal right. It is intended to regulate the procedure to be followed by the civil courts. If I am going to discuss about the history or background of the code, then it is very important to mention here that before the year 1859 in India, there was no uniform code of civil procedure. Before 1859, different systems of civil procedure existed in different parts of the country. Even in the same region, different systems of procedure prevailed. In Bengal alone, there were as many as 9 different systems which were in force simultaneously. The first Uniform Code of Civil Procedure was enacted in the year 1859. Subsequently, in 1877, a new code was brought in force to overcome the defects of the Code of Civil Procedure of 1859. As in the Code of Civil Procedure of 1859, there were some defects. To overcome the defects of that code, in 1877, another Code of Civil Procedure was enacted. But again, in 1882, another code was enacted. This code also underwent amendment from time to time, and finally, it was in 1908 that the present Code of Civil Procedure came into force. The Code of Civil Procedure 1908 came into force with effect from January 1st, 1909, while the Amendment Act 1976 came into force with effect from February 1st, 1977. The code has recently been amended in 1999 and in 2002. Both these amendment acts, I repeat, both these amendment acts came into force with effect from July 1st, 2002. Now, recently, the Code of Civil Procedure 1908 has also been amended by the Commercial Codes Act 2015, which has received the assent of the President of India on 31st of December 2015, but shall be deemed to have come into force on 23rd day of October 2015. Now, scheme of the code. The Code of Civil Procedure 1908, for the purpose of its study, can be divided into two parts. The first part of CPC is called body of the code, and second part of the code of CPC is called schedule of the code. What is in the body of the code? In the body of the code, the body contains 158 sections, which are grouped into 11 parts. And after the body of the code, the first schedule follows the body. The schedule is classified into 51 orders, which are numbered in Roman language as order 1 to order number 51. Each order deals with the specific procedural matter and contains the rules thereof. If we are comparing the body of the code with the schedule of the code, body of the code contains the sections. The sections lays down the general principles of jurisdiction, while the schedule relates to the procedure, method, manner, and mode in which the jurisdiction, which is created by the sections, may be exercised. Now it is very important to discuss with you students, if the rules of the CPC and sections of the CPC are inconsistent with each other, then which will prevail over which? It is very important to discuss this point. If the rules of the CPC are inconsistent with the rules, if the rules of the CPC are inconsistent with the sections of the CPC, then the sections of the CPC will prevail over the rules of CPC. It is very important. The body of the code is fundamental. What is the meaning of fundamental? If any amendment is required to be carried out in any of the provisions contained in the body of the code, that means to say, if any amendment is required to be carried out in the provisions which are given in the sections of the CPC, then it can be done only by the legislature. That means to say, our parliament can only amend the body of the code, the sections of the code. But if the amendment is required in the schedules, then it can be amended by the high courts by virtue of the power conferred upon them by sections. And what are the number of sections? Section 121 to 131, section 121 से लेकर 131, except section 123 and 124. That means to say, section 121, 122, 125, 126, 127, 128, 129, 130 and 131 of the Code of Civil Procedure 1908. If we are dealing with the scope of the Code of Civil Procedure 1908, then the question sometime asked in the examination, whether the Code of Civil Procedure is exhaustive or not, then the answer is very diplomatic. The code is exhaustive on all those matters which have been specifically dealt by the Code of Civil Procedure. But however, if any matter is not specifically dealt under the provisions of the Code of Civil Procedure, then it is not exhaustive on the points not specifically dealt with therein. The legislature is incapable of contemplating all the possible circumstances which may arise in future litigation, and consequently for providing procedure for them. Then what will be happen if the legislature does not make any provision for any matter? Section 151 of the CPC has been enacted for that purpose. With regard to those matters, the court has always the inherent power to act according to the principles of natural justice, equity, and good conscience. That means to say, if any point is not specifically dealt by the Code of Civil Procedure 1908, then the civil court has always the inherent power under section 151 of CPC to do the justice according to the principles of justice, equity, and good conscience. The language of 151 of the CPC can be specifically read as under: nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of the process of the court. That means to say, CPC will not stop the civil court to effect the inherent power of the Code of Civil Procedure. If any specific matter is not dealt with by the provisions of CPC, then the civil court has always the power to make such incidental orders as may be necessary for the ends of justice. How to interpret the provisions of CPC? As the CPC is neither to create any right or not takes away any right, so the provisions of CPC must be interpreted liberally and in such manner as to render the enforcement of substantive rights effective. And what is the nature of the operation of CPC, whether it is retrospective or not? Then the answer is, although CPC is a procedural law, but it is not a retrospective in operation. It can be asked in the examinations. Thank you, sir.